Welcome everyone. I am Brandon Kennedy, President of KFG Financial Group. We are a Troy-based financial planning firm, and we exist as a firm to help our clients live their best financial life. We do that by acting as a guide on their financial journey and helping them achieve what's most important to them. Today, we're continuing our financial wellness series where we interview different experts in the financial planning field. October is Estate Planning Awareness Month, and we're excited to have Betsey Rubel. So Betsey, welcome.
Thank you.
Welcome back, and we're in person, not doing a Zoom. How great. Give us a quick intro, bio, and kind of talk about your practice and what you do.
Okay. Thank you very much for having me. So my name is Betsey Rubel. I'm an estate planning attorney. I've been practicing for more than 20 years in this area. I practice in estate planning and probate administration. So my whole practice is really meeting with clients and helping them achieve their goals through their different estate planning documents. I work a lot with Brandon as a financial planner, where we can coordinate these things together and make sure everybody has that peace of mind of having all their documents in order.
Betsey does a great job in estate planning, and before we jump in, we're going to do something a little bit different where we talk about different stages of life. But before we jump into the details of estate planning, we wanted to just go through and provide a resource for what is estate planning. Let's define that, and then Betsey, if you can tell us a little bit about what are the essential documents that make up an estate plan? Can you give us a quick overview of that?
Yeah, absolutely. So estate planning in general is really a comprehensive plan about how you are going to, one, transfer assets to your loved ones upon their death, and two, how to plan in the event of a disability. So there are four, basic documents that most families have. One would be a will, and a will is where you're going to state what you want to happen to your assets. It's also where young families would designate a guardian for any minor children. Most clients end up having a trust. When you have a trust, the trust is actually what spells out how you transfer assets. A trust avoids probate, and a trust also gives you greater control about how things are paid out to your kids. A power of attorney document, that's the document where if you're disabled and you need somebody to pay your bills, file your tax returns, that document allows you to appoint somebody to do those things for you. And then you would also have a patient advocate designation, which is that medical power of attorney that allows somebody to make medical decisions for you if you are disabled. So there are many other ancillary documents involved, but those are the basics that most families will have.
Yeah, and I think a lot of people have this perception that estate planning is only for the ultra wealthy, or even a trust. Sometimes they have this stigma that it's a trust fund and that's only for millions and millions of dollars. But can you dig into a trust document a little bit and what some of the benefits of that might be?
Sure. So I think what people don't always realize is even things like life insurance for young families, oftentimes that's a big asset for them. If you don't have a trust or don't have assets that flow through a trust, your kids would receive everything when they turned 18. So there's not a way of controlling how they're going to receive assets. When you do a trust, you can be very specific and say they can use it for college, they can use it for a down payment on a house, they can use it for medical expenses, and then they receive staggered distributions when they're old enough to be able to be financially responsible. So you have a lot of control, and it's really kind of an individual choice about how you want to structure a trust so that it reflects your family's wishes and values. So the control thing is big. The other thing is avoiding probate, which is that court process that most people don't want to go through. It keeps the court kind of out of your business, and whoever you nominate as the trustee of your trust is the person that actually works to distribute assets according to your wishes.
And we're going to get into the different stages of life, and I think we started on it a little bit, but let's start at the very beginning. You turn 18 and you are now an adult. You're not on your family's plan any longer. You have some responsibilities. So where would you start that journey on the estate planning side as a young adult?
Sure. So a lot of times it's really just having power of attorney documents in place. I do a lot of like college kids who are going away to college when all of a sudden they realize, wait, mom and dad can't do anything for me if something went wrong or they needed to take care of something. So many times just a young, 18-year-old is going to have the power of attorney for finances, and then that medical power of attorney, which is that patient advocate designation. And that's something that, mom and dad don't decide for you. That the client is now the 18-year-old now adult who has to make those decisions. And kind of a little bit later in that stage would be, do you own a house? A lot of times that might be the first asset that someone has, where you want to look into maybe doing a quitclaim deed or a ladybird deed, or just a way to avoid probate on those initial assets. So that's really the biggest thing initially, is making sure those power of attorneys are set up.
Sure. No, and it's not too early to start that. A lot of our clients start very young. They're going to open up IRAs. They need to make sure their beneficiaries are in place, and it's just the right thing to do to have that dialogue early on. Then we fast forward a little bit further into life, where potentially we have some young kids. And I think this is where, like you had said, right, we're starting, maybe we don't have a ton of money in the bank or in our 401k plans, but we may have a large life insurance policy. We may have a home. So talk about that, how that correlates to if we have a husband and a wife, and they have a couple of kids that are maybe under 10 years old. What does an estate plan look like now?
So that's often really the first time I see clients, and having their first child is a lot of times an impetus for sitting down and making these decisions. So the big thing is naming a guardian when you have minor kids. The will is the document where you're going to name who you would want to serve as guardian if you passed away with young kids. So that's really important, because that's a very personal decision and something that families need to think about. And then again, structuring a trust. A 10-year-old wouldn't be able to inherit from you without a lot of difficulty. So structuring a trust so you make sure that your kids are provided for according to what you want for them. And so that often is a time where people are really thinking about like providing for education. How are we going to plan for this? Making sure that your kids are financially responsible as they age. So those are the things that someone's going to end up looking at in terms of a trust. And then, choosing who do you want to be the trustee. Your kids can't do it at that age. So who is the appropriate person to, that's in your life that you think would do a good job handling those financial assets for your kids?
I know personally we've looked at this. These are never fun conversations to have, right? They're important. But we separated who would take care of our kids, right? The guardians within the will, and then had some checks and balances and separations within our trust, so that there's not that emotion that may go along with, if this plays out and both parents are deceased, that's at a very emotional time. So to have some checks and balances, can you talk about the differences between guardianship and then a trustee on the assets and how that would actually play out?
So a guardianship, a guardian is going to care for the person. So they're making sure that that child, making decisions about how, where that child goes to school and how that child is cared for. The trustee is in charge of the money. And that's why where you say the checks and balances, the trustee oftentimes gives money to the guardian to kind of, to help with things with the kids. So the trustee is going to make sure that the assets are managed properly. They're going to work with financial professionals to make sure that that money is growing for the kids, and they're going to make distributions according to what you've told them you want. And so that trust document can be very specific, and so you can look at that and say, okay, this is what they wanted, and that trustee has to follow what you say in the trust document.
Yep, and I think the biggest benefit of that is there are people in life who are very good at caring for young kids, but they may or may not be equipped to make major financial decisions or good financial decisions. So that's where we can do that.
And I tell clients too, there are some times where the guardian and the trustee are the same person, but they have to know going into there, you're going to have to totally trust this person because they're serving both roles in that event. But a lot of times it is a different person acting because it's a different skill set.
We're going to talk more kind of at the end of this session about having open communication, and that's always a good thing to have. These aren't documents that you should be hiding. We'll get into that a little bit more, but before we do that, let's fast forward maybe another 10, 15 years. So now we have a family maybe in their 50s, maybe 60s, and have grown kids, maybe getting out of college, maybe they're 30 and still living at home. That happens more and more these days.
Sure.
How do we structure a plan, or how do we maybe modify, and we can talk maybe amendments within a trust. So let's go, the young family already had a trust in place. How might that plan change as the kids get older, more responsible?
Yeah, so absolutely. A lot of times clients contact me when their kids are, out of college, into their 20s, 30s, where they're trying to decide, should we put them in charge of the trust? Previously, maybe it had been aunt or uncle or a friend. So a lot of the decisions there are, do we make our kids fiduciaries as successor trustees, power of attorneys? And that's very individual to each family. Some adult children are absolutely able to do that, and it's a no-brainer. Sometimes parents still have some concerns about how how that would work with family dynamics. That's a big thing, whether or not you want to name one child as a trustee or two kids as co-trustees. Those are all decisions, and that's really where you look at how does your family work? What do you think would work? You really want to avoid conflict with your family. Like how do you structure it so it goes smoothly? A lot of times there are adult children who still maybe need some structure within the trust about how things are going to be paid out to them. Oftentimes I'll put a clause in there that requires a beneficiary to meet with a financial planner prior to receiving a distribution, so they can sit down and make some intentional decisions about how they're going to invest any money that they receive. So that financial responsibility at those ages are a lot of conversations that I have with a client who maybe has some older kids.
Sure.
The other thing that we always look at is funding, which is the process of making sure your trust owns your assets or is the beneficiary of your assets. So I'll have a family that comes in who has a pre-existing trust that maybe they did years ago, but they never followed through and did those changes to make sure their trust is funded. So that's something I always go over with a client who is coming to me with an existing estate plan. Because a trust is just a piece of paper unless it actually owns the assets.
Yeah, we see that very often where they'll come in and we look at their accounts, we look at their beneficiaries. Not once is the trust reference, but they say, here's my trust, everything would go there, and that's just not the case.
No.
These are very much by contract on what the registration of the account says, so very important. That's a great tip. So, all right, now let's kind of go forward even further, where we're getting more elderly clients and or disabled, right? We could have some mental capacity issues with Alzheimer's, dementia. Let's just look at, and I think where this comes from often is the parents. So you might be in your 60s or 70s, you have a parent in their 80s or 90s, making sure that the proper plans are in place. Can we talk about that stage of life in estate planning in that front?
Yeah, really the most important thing there is timing, because as you mentioned, capacity issues. In order to execute estate planning documents, you have to have the capacity to do that. So catching those things before they get too far where you can't make your own decisions is very important. And doing it in a way, it's real to these people at that stage in their life. So doing it in a way that's compassionate, where you kind of take your time and you can sit down in a non-crisis situation and make those decisions, because it's really important to have those power of attorney documents in place, the patient advocate designation in place, because those will be used at some point. So that's a big focus there. And again, reviewing the way everything is set up in terms of their existing estate plan is important. But I just think the way of going about it at that age, with that age of client, is always a little bit different, because you just want to make sure that everything is taken care of properly and that everybody feels comfortable. And so I just think timing really is the biggest thing there.
So even if you have an estate plan in place, we have, by doing this the last 20 years, have seen mistakes. So can we talk a little bit about maybe some of the common mistakes that you see for people that already have a plan in place, and some of the ways that we can maybe remedy those?
Sure. The biggest thing is really making sure that your trust is funded. We talked a little bit about that earlier, and what that means is you really need to identify each asset that you own and have a plan as to how that flows through your trust. And that requires some additional work. It requires going to the bank, making sure your beneficiary designations are updated, really dealing with each thing. And a lot of times, somebody will do an estate plan, they'll fund their trust with the assets they own at that time, but then they buy a new house, or they open a new account and they kind of forgot that they had a trust. So really reviewing that and making sure that everything is funded is very important. Anything that's not funded ends up going through probate if there's not a beneficiary on there. So we need to make sure each of those are taken care of. The second thing is really kind of like a do-it-yourself changes to documents. People will come in where they made their own amendments, where they scratch things out and write someone else's name in there, and that ends up being a disaster. So really, if you're going to make some changes, sit down with an attorney, make sure that they're done right, so there isn't any question as to who made that change or why you made that change. And the last thing I see a lot are people who are changing deeds to their house. They think, my grandpa added my mom to the deed, and so, this will work, and this is how I'll avoid probate. But deeds are something that are very specific, and so people can really mess that up pretty easily if they're not done right. And that creates a big title problem and a problem down the road. So don't try to do your own deed to a house in order to avoid probate. Just talk to somebody. There's lots of ways to do it properly.
Yeah, and I think the general recommendation, and if you can just kind of confirm that, is the way you avoid some of these mistakes, or just even if your plan hasn't drastically changed, just maybe do an audit, right? And how often do you recommend, and what would that entail?
Probably every 5 to 10 years, I'd say. Maybe sit down with your attorney and see, if there's any changes that have to be made. Maybe there's not, but it's just a good time to sit down and review everything. Or if you have a major life event change, a divorce, a remarriage, birth of a child, all those are kind of an impetus for sitting down and talking about that. And things like, retiring, buying or selling a business. Any big life events are a time you want to sit down and relook at your estate planning documents.
I think that's a good lead into our last section of what we wanted to talk about for today. It's something that we're going to introduce next year for all of our clients, and we're calling it a legacy session. So we work with a lot of multiple generation families, and I'm sure you do the same, right, as far as how you meet new people to do their estate plan. And what we often find is they are separate conversations for each, and that shouldn't necessarily be the case, right? And if you are in your 60s and you're going to pass money on to your kids, let them know what your wishes are. Talk through what the plan looks like. Talk through the trustees and what your expectations, not just have it be on paper. So can you talk about where open communication and how you've had maybe some successes in doing that by bringing the families together and talking through
Yeah. So, the client, I have confidentiality with my client, but what I tell them is, it's your choice to share this with everybody, and I recommend that they do, because it's better to be upfront about these things. And if they want to invite their adult children to a meeting, I am absolutely open to that, because a lot of good questions are generally generated at something like that, because these adult children are actually going to be implementing the estate plan, so they really do need to know what's in there, what do I do, what kind of steps do I take. So having that communication is really important. And again, how I had talked earlier about timing, is doing it in a time where you're not in the middle of a crisis situation where somebody has to move into a nursing home or assisted living. We've never had these conversations before. So sitting down when everybody is in a good spot and talking through it makes everything go so much better. And then if there's something that comes up that you think, the client thinks maybe needs to change based on those conversations, that can happen as well. But doing it when everybody, is kind of getting along and sitting down and having those open conversations.
Another area that we have conversations with clients is a lot of our clients, they live below their means. They built up a legacy that, they're the millionaire next door. They didn't really ever think they would have the wealth they have. And through 30 or 40 years of sacrifice, they've built up an estate that they are very proud of, and they want that legacy to live out beyond them. So can you talk about maybe some of the conversations or the areas that we can start to look at some of these families that are affecting not just their kids' lives, but their grandkids, and really leaving a legacy, and how some conversations can go that way?
Yeah, absolutely. So there are ways to provide for your grandchildren within the estate plan, and there are ways to incorporate your own values into your estate plan by the way it's written. People will put value statements in there, encourage charitable giving. There are ways to encourage your children to kind of carry on that same legacy. So, the importance of education, a lot of times within these estate planning documents, a lot of times people will, put language in there providing for grandchildren's education, and just doing things to kind of help your family or encourage them. So, those are all things, not only the conversation, but the documents themselves, I think can reflect, though, the values that your own family has.
Yeah. And I think that's our goal with these legacy sessions, is to have just an open dialogue of this is where we're at. At some point, we know it's inevitable, this money's going to pass on, and how can we, as an entire family of multiple generations, make sure that our wealth is really serving a greater purpose. And estate planning just kind of fills in the details and tells a story after your life. Well, thank you so much for today. This was hopefully you learned a little bit about the documents, depending on where you are in your stage of life. So if you can talk just a little bit, Betsey has helped dozens and dozens of our clients. Talk about what that process, because sometimes it's hard to take that first step or make that phone call to talk about what happens when we die in our estate. But you do a great job with just making that an easy process. Talk about maybe what that first meeting looks like and kind of where it goes from there. Yeah,
so the first meeting is where we kind of go over just generally what somebody's wishes are, what they would want to see in their plan, kind of touch on what types of assets they have. And I always tell people too, if you don't know the answers to all these questions at the first meeting, that's okay. The biggest thing is just making the appointment, sitting down, talking about everything, and then I end up generating like a list for clients after that. Like, you didn't know about this at our meeting, but that's fine. This is something that you need to think about and get back with me on. So I think just making that first step, making the appointment where we go over and just determine what decisions have to be made, even if you don't know what the answers to those things are, but making that first step is really important. So, and once that happens and we kind of start going on the document drafting, it is a fairly straightforward process once those decisions are made, but I'm here to guide people and to answer questions and to bounce ideas off. So that's just make the phone call is really the important first step.
Absolutely. And again, sometimes if we have these arbitrary estate awareness months, October is estate planning awareness month. So if that's your driver, maybe you watch this video and you look at, hey, I'm in this stage of life and want a second opinion, we'll put up Betsey's contact information, reach out to her, super down to earth, easy to work with, served a lot of our clients well, and I encourage you to take that step and get that in place. Other than that, we appreciate your time learning and joining in on another one of these financial wellness sessions. We like to say those that have a plan and a process behind their financial decisions have better outcomes and more peace of mind in their overall financial legacy and plan. So thank you again, and we'll tune in and see you next time. Thanks.